Courthouse case People versus Rashad Ahmad.
Ready, Your Honor. Good afternoon, Your Honor. Hassam Qudsi on behalf of the defendant.
Rashad Ahmad.
I have a plea form in front of me that indicates that the defendant is going to be pleading guilty to attempted interfering with electronic communications. That's a 1-year misdemeanor. That's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. The defendant is also agreeing to pay full restitution, and there's a sentence agreement, although I cannot bind the sentencing judge. In this case, there's an agreement to no upfront jail. The prosecutor and defendants are agreeing to that.
That's correct.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Rashad Ahmad.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted interfering with electronic communications. That is a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Still wish to plead guilty?
Sorry?
Do you still wish to plead guilty to this charge?
Your Honor, may I say something?
When the judge asks whether discovery was ever provided, the defense calmly answers no. The courtroom immediately tightens. Why not? The judge presses. The response is blunt. Because they thought there was already a deal. The case, People versus Rashad, was supposed to be wrapping up with a plea agreement. Instead, the judge now realizes the defense claims they never received police reports, 911 recordings, or key evidence. The prosecutor insists discovery had been sent to prior attorneys, including the public defender. The judge stares at counsel in disbelief. How is the court taking a guilty plea when the defense hasn't even reviewed the evidence? The frustration is clear. This is no minor oversight. This is a breakdown in procedure.
Just something happened. The victim is here. Just want to let you know.
Okay.
And may I approach, Your Honor?
Yeah.
I'm sorry about that.
All right, sir, understanding the maximum penalties in this case, do you still wish to plead guilty to this charge?
Yes, sir.
And to that charge, how do you plead?
Yes, sir.
How do you plead? Guilty or not guilty?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form. Is that correct?
Yes, sir.
Do you have any question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
July 8th, 2025, at the location of 1480 Parkwood Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. What did you do what did you do that makes you think that you're guilty of the offense of attempted interference?
May I form the question, Your Honor? I'm sorry. Did you text her? You put a daughter via Zelle and text her. Did you do that?
After the court, you mean?
No. The judge is asking you, did you text her? Did you text her, send a text message via Zelle?
Yeah.
The defendant stands sworn in, ready to plead guilty to attempted interfering with electronic communications, a 1-year misdemeanor. The agreement is simple. Plead to count 3. Counts 1 and 2 get dismissed, no upfront jail. restitution paid. He confirms he understands a maximum penalty, confirms he gives up his right to trial, confirms no one forced him. Everything appears routine until the judge asks for a factual basis. What exactly did you do? The defendant hesitates. When asked if he texted the alleged victim after court, he says yes, but quickly adds it was only sending $1 through Zelle, not a real text. The judge leans forward. This explanation doesn't match the charge. The clean plea hearing begins to unravel.
Yes, I did.
I,
I don't know how that,
It's like it was send money. It's not text.
yeah, I know.
Yeah.
how does that, I don't know how I get to the charge.
This is the only electronic device that he attempted to do. He was texting her, giving her $1 through Zelle so he can text her a message.
Sir, I'm just saying, whatever is being said to me doesn't sound like the offense.
Mr. Ahmad, on that date, were you with a Kimberly Chavaria?
مش فاهم.
He doesn't understand.
Like,
Who is
no,
this Kimberly? I want to he's saying. He doesn't understand. مالك سمع بالاسم Kimberly?
Yeah, هي اسمها. Yeah.
She's asking you. You were with her on
Yeah.
that date?
Yeah.
Okay.
Okay. And on that date, did she try to contact 911?
Yeah.
And did you take the phone from her?
No, I didn't take the phone because she didn't try with the phone. She did try with Alexa
Did you tell Alexa to stop calling 911?
because Alexa said just one time because Alexa said she can't call 111 and start talking something else. That's why I stopped Alexa because Alexa didn't like how we can say
So you stopped Alexa from calling 911?
and not for calling no. Alexa after she called 911 and Alexa it doesn't work for call 911 and they start talking like
Did you take her phone from her at some point?
no.
All right, well, I can't accept the plea. I don't have a factual basis.
Your Honor, so we do a preliminary exam.
The questioning turns sharper. The judge asks whether the alleged victim attempted to call 911. The defendant admits she tried, but says it was through Alexa, not a phone. Did you stop Alexa from calling 911? He admits he told Alexa to stop, claiming it wasn't working properly and was talking something else. The courtroom grows quiet. Did you take her phone? He denies that. The prosecutor and defense try to clarify, but the answers remain inconsistent and unclear. The judge finally draws a line. Without a clear admission that matches the elements of the offense, there is no factual basis for the plea. I can't accept this plea, the judge says firmly. The deal that once seemed guaranteed collapses in real time.
Your Honor, right,
Okay,
asking.
there will be a preliminary exam set. I will assume that all discovery is complete.
Oh, no, there was no.
I will assume.
Your Honor, there was
Trial
no
can't
discovery.
accept a plea. Pardon?
There was no discovery. We didn't get any documents, police report and anything. Because at that time, we thought that we have
Well, why am I taking a plea if there's no this doesn't even make any sense. What?
Your Honor, in my file, discovery is tendered. You've sent over the media as well as the 911 call has been uploaded.
I never received it, Your Honor, 100%.
Was it sent to him? He's been the only attorney on the case, so.
There was another attorney before me, Your Honor. It was a public defender.
Did you get the discovery from the public defender?
No, Your Honor.
Why not?
Because
I mean,
at that
most-
time, we have a deal that's
For
the
Pete's
clients will.
sakes.
Your Honor, I believe we sent discovery to both the public defender. I believe Ms. Stedman was also on this case prior, and discovery was also sent to her.
And you're saying from neither prior attorney did you get discovery?
No, Your Honor.
Can you send it to him now? Because I'm setting this for exam. I'm not playing around with this anymore. Send the discovery to them This will be set for preliminary examination in person, September 9th, 2025, 9 a.m. That's before me.
Now visibly frustrated, the judge confronts both sides. Why is there no confirmed discovery? Why are they attempting to resolve a felony-level allegation without reviewing evidence? The prosecutor maintains discovery was uploaded and sent to prior counsel. Defense insists they never received it. The judge refuses to proceed blindly. I'm not playing around with this anymore. The court declares. The plea is rejected. The agreement effectively dead. Instead of sentencing, the case is set for a full preliminary examination in person on September 9th. At 9 a.m. discovery must be sent immediately. Bond is continued. What was supposed to be a quick plea hearing turns into a procedural reset. And now the case moves forward the hard way